Hello, this is Robert Larson. I'm an attorney and I'm the owner of the Larson Law Office in Mesa, Arizona. And a couple of months ago, I made a video and posted it on YouTube talking about what to do if you get a restraining order served against you. So that could be an order of protection or it could be an injunction against harassment. But basically, if someone serves a restraining order against you, what should you do? And you should watch the video if you have questions about that. But the short answer is call an attorney. That's the main thing to remember. And it's really simple advice. In that video, I referenced that if you want to challenge the order of protection or injunction against harassment, basically restraining order, if you want to challenge it, you have the right to a hearing where you go in front of a judge and the judge will determine whether the restraining order is going to stay in place permanently or if it's going to be dismissed. And in that video, I kind of referenced that these hearings are very difficult to do without an attorney and without proper preparation. But I didn't have enough time to really get that much into it. So I wanted to make this video as a follow-up to talk about what those pitfalls are if you decide to challenge the restraining order and have a hearing. So the number one thing that causes problems is when you request the hearing, you will have one scheduled within 10 business days. So that's 2 weeks. Now, most of the time it's going to be about 5 or 6 business days or maybe 7 because the courts need to give themselves a little bit of a buffer in case something happens. So they schedule these hearings very quickly. That means you don't have time to prepare. You don't have time to go gather evidence that might be relevant. You don't have time to get your witnesses lined up. You don't have time to go talk to an attorney and hire one and get that attorney up to speed on your case if you've already scheduled the hearing, and especially if you're trying to talk to an attorney 2 or 3 days after it's been scheduled. At that point, you're talking to an attorney and you're telling them, hey, I've got a hearing coming up in 2 or 3 days, and can you be ready and represent me? I've had many calls like that, and I know other attorneys have as well. So that's the number one thing is don't request a hearing until you're prepared. Get your evidence together, get your exhibits together, get an attorney, put together a plan and make sure you're ready before you even request the hearing. Because once you request it, you're gonna have to be in court and be ready very soon after. A lot of times people have restraining orders and then they challenge them and they're not prepared. And so they lose and the restraining order stays in place. And then later on, they get the evidence that would have helped them win their case if they had been prepared. So that's the number one thing is to just be patient. I know it can be really hard when you can't get into your home or your business or see your children, things like that. It's very difficult to wait, but just wait. And then for some reason, I referenced this in my other video, people think that the 10-day rule means that they have to challenge it within 10 days, and that's not the case at all. You have any time to challenge it. It can be months later and you can still challenge the restraining order, but it's the 10 days references that the fact that they have to schedule a hearing for you within that time. So anyway, that's the number one thing is be patient, get your case ready before you schedule your hearing. The second thing is you have to remember the restraining order is about you. It's not about the other person who got it against you. So if you go into court and you say, yeah, I did some bad things that I shouldn't have done, but the other person did it too. So in other words, yeah, I hit the other person, but the other person hit me too, so it's equal. That guarantees you're going to lose. If a judge hears that, the judge has to keep that restraining order against you in place, and you're going to lose. And when you lose on a hearing for a restraining order, it can have some pretty significant disadvantages for you. It can affect you pretty considerable. So you don't want to do that. You want to know ahead of time what a good defense is and what is not a good defense. So if going in there and saying she hit me and so I hit her, it's all equal, that's a losing strategy right there. You're going to lose every time. So it's all about your behavior, and the other person may have had bad behavior too. And if you got a restraining order against them, then that might be grounds to keep that restraining order in place against them if they challenge it. But the hearing that you have for the restraining order against you is only about you and your behavior. So you can't bring in other people's behavior to justify what you did, okay? So you need to know that ahead of time, because so many times people have gone into these hearings and they basically just admit the allegations that are made against them. They testify in a way that makes the judge have to rule against them. So that's all the more reason to talk to an attorney, but that's one thing to remember. The third thing is when you go into a hearing on a restraining order, you can't bring up things that happened 5 years ago or 2 years ago or whatever else, and whatever period of time that something happened that you think is relevant, it's not. The only thing that's relevant are the allegations that were made against you. So in the petition for the restraining order, the person who got it had to list specific dates and events that took place, and based on those events, the judge either gives them the restraining order or doesn't. If they don't, then obviously you wouldn't have anything to challenge. So obviously at this point, they did give it the restraining order. So you have to focus on what has been alleged in the paperwork. You can't bring up other events to try to show that the other person is bad or that you're justified or anything. You really have to show that the allegations made against you in the paperwork are not credible. And on the other hand, if you're the one who got the restraining order, you have to remember you're limited to the things that you alleged in your paperwork. You can't start bringing up other things that happened before that. Finally, the fourth thing is the judge only has two choices when you do a hearing on a restraining order. The judge can either keep it in place or the judge can dismiss it. The judge does not have room to compromise and things like that. In family court, so if you have children together, you can also have a case in family court, and the judge there can compromise and do some things that are a little bit more flexible. And so if you have a family court case, then you want to move those two cases together, get your restraining order and your family court case together, and have one judge deal with it, because that judge is going to have a lot more power to be flexible and do different things. When you're just challenging the restraining order, it's either going to be dismissed or held in place. So if the judge basically believes your accuser is 51% likely telling the truth and believes you 49%, they're going to keep it in place, even though it's a close call. And they're not even going to tell you if it was close or not. They're just going to keep it or not. If it's 50%, so if the judge listens to both sides and has no idea who to believe, then the judge has to dismiss it. So sometimes it can be a really close call, and so you need to understand that and understand how to plan your strategy based on those facts. You also, another thing, I know I said the last thing was finally, but one more thing is if you're going to have a lot of witnesses and a lot of evidence, you may need to ask for more time, because initially when they schedule your hearing, they're not going to give you that much time. So you either need to plan accordingly and make sure you can condense your case into the time that's allotted, or you need to request more time ahead of time and make sure that you have enough time to present your evidence. So those are some of the things to remember. There could be other things, but those are kind of the big things that I think are helpful. If you get a restraining order served against you and you want to challenge it, those are the things you should remember. But again, going back to my other video, the number one thing you should do is talk to an attorney. You should not go into one of these things unprepared. It can have significant consequences against you if you lose. So anyway, if you have any help, if you ever have a need with help against a restraining order, and hopefully you will never do, but if you do, give us a call, 480-459-6082.